We say that the IBAC has been causing interruptions to our ability to prosecute this matter. I've been involved in a number of proceedings, all of which have been withdrawn at the last minute. In all those proceedings, or in the proceedings that were the most troublesome and time-consuming, the judicial officers had acted improperly. There were complaints made against them to the IBAC. The IBAC has then effectively not complied with its statutory obligations. Some of those complaints the IBAC raised in the judicial mediation of this matter as a bargaining tactic.
Well, gone.
No, what they're saying is they deliberately did this so as to get an advantage in this matter.
But I understand that they are now investigating the complaints you've made.
No, we made several complaints. They have decided to investigate one of those complaints. The other of those complaints they haven't.
They haven't made a decision on those.
Well, some of them they haven't made decisions on. Some of them they have improperly dismissed after seeking to negotiate with us if we would make some concessions in this case on the basis that
We can't go into those discussions that have occurred during mediations like that. It is most improper to raise with me.
No, Your Honor, if it is fraud, there is a fraud exception to that.
Well,
there is a fraud exception to that.
You cannot stand at the bar table and make these allegations not on affidavit because I will not hear in this court hour.
I'm happy to make them from the witness box.
You cannot at this turn up and orally make these sorts of submissions.
I am happy to give evidence, Your Honor.
I am not going to allow you to come along at the 11th hour or in fact the 12th and a half hour and make these sorts of allegations on the basis that this is the reason for your adjournment.
They have been made in writing, Your Honor. They were made to the court at the time that those things were taking place. They were made in real time. IBAC was given an opportunity to apply to the court for an injunction. We had written and provided our version of the matter to the court in real time. At the time the event occurred, we had raised with the court that the judicial mediation was pursued fraudulently. But the documents should be with Your Honor. In fact, they have been lodged in this proceeding. This proceeding has been continuing for quite some time. There has been a lot of material that's been lodged in this proceeding, including evidence of the alleged fraud. It has already been filed in this proceeding. It was before Justice Guinane in relation to the costs orders that His Honor was considering. So we have already filed the evidence of the fraud on affidavit in this proceeding. We have a right to be able to rely on that. What we say is that the IBAC has consistently created impediments in a way that they would tactically benefit from the disruption that was being caused. Mr. Brereton, what he has put in submissions before Your Honor is contrary to what he had expressed to me and Ms. Zhu in judicial mediation. The evidence of that, or some of the evidence of that, has already been filed through the matters that were raised in emails and a number of other documents that were exhibited to affidavits lodged in the proceeding. None of that has been contested by the IBAC on evidence. In fact, one of the matters that the IBAC, I understand, is seeking to introduce at the last minute, we say, is an attempt to sabotage another complaint that the VI is investigating the IBAC about. And that has to do with the improper disclosure of our complaint in relation to the LSBC in a proceeding. This was in violation of the oath of office of the officer that had disclosed information about that complaint. So we say now they have brought a summons to have this court decide a matter by ambushing us, which they will seek to use with the VI to essentially apply what happens here as a precedent to a previous matter. There's a number of considerations, and the most urgent prejudice or the most recent prejudice that we've experienced is an order that Justice Gorton has made in a related proceeding whereby His Honor has prevented people that were previously assisting us in the preparation of documents from continuing to assist us in a manner that was most improper. It is currently the subject of a petition that alleges that His Honor has committed criminal offences. 84 people have signed that petition, put their names to it. It's a petition addressed to Parliament and the Chief Justice. What we say is that Justice Gorton improperly assisted the LSBC, and there were a number of matters put to His Honor, matters that a reasonable justice would not have left uninvestigated, including the allegations made against him and his contact with the LSBC. His Honor has not responded to any of those allegations, and we have made a complaint to the IBAC in accordance with what the regulation of the law requires us to do. The IBAC refused to investigate the matter, did not determine that the complaint was improper, but refused to investigate the matter after taking 6 months with the complaint, when 4 weeks after receiving the complaint they're required to notify the party whether or not it's a public interest complaint. Now, the issue with that, Your Honor, is that because of IBAC's failure to timely to get back to us, we weren't able to take next steps. We sought to bring an application in this court for mandamus in relation to IBAC's non-performance of duty. Justice Gorton improperly prevented us from raising that application, and that matter again is a matter of public record that's been raised in a petition that 84 people have signed already. It was first brought to His Honour's attention that the application was being lodged on indistinct. His Honour read the document, concluded that we had, so His Honour was aware of our allegations against him. Also aware of our submission that if those allegations were being made frivolously it would be contempt of court to scandalize in the affairs of the court. His Honour found that we had sincere grievances against him and refused to investigate whether or not the allegations being made against him were proper, and refused to charge us with contempt or state that it was improper for us to allege those matters in the public domain. Essentially because of IBAC's non-performance of duty, we have been forced to escalate the matter with the Oversight Committee in Parliament that oversees IBAC's functions, and that has tremendously increased our workload, and it's caused a lot of disruptions to our proceedings. We're battling these matters on a number of fronts, but it is absolutely critical that we do not let what IBAC is doing slip under rug, and they are deliberately trying to make things as difficult as possible and as cumbersome and time-consuming as possible, and they're taking extremely fine technical points. So we're under-resourced, in great part because of the disruption caused by the Legal Services Board's improper conduct, and the IBAC refused to do its job, and it is counting on the fact that the matters that we're raising, if it doesn't cooperate, will be very time-consuming and will test the patience of judicial officers and so on. So in effect, it is seeking to prevent the court from determining the truth. All we want is for the court to determine the actual facts of the matter. What they're saying is that determination of the facts of the matter or the truth is not in the interests of efficiency. The fact is that these matters now are a public scandal, and they will continue to be one so long as the court ultimately decides what the true facts of the matter are. And that's all we're seeking. We have a fundamental human right to hold the government to account. It's a constitutional right, and it is also a derivative of the other fundamental rights that we have. So that's one part of the situation. The other matter that Your Honour should be aware of, but I will be thorough and make sure that I've covered it, is that initially the proceeding that we had brought, this one, it was brought on two grounds basically. The first ground was that the IBAC made a mistake, an error of law, jurisdictional error to be more precise, in not identifying that the complaint that we had made was a public interest complaint. The second ground was that the IBAC had made a jurisdictional error in not properly considering the merits of the complaint. Now, this complaint was made on 10, I believe, of January 2022. It was dismissed in March 2022 to April 2022, the 8th of April 2022. And then when these proceedings started and His Honour gave judgment indicating that we had an arguable case, by then I had lodged a fresh complaint in relation to the same matter with IBAC. IBAC reopened a complaint that it had shut down in April 2022. Now, we've written to the IBAC. We've written to this court, and we have stated based on authorities, a number of authorities that we've highlighted. I can identify them again. The IBAC, being an administrative body, did not have the jurisdiction to reopen the matter that it had conclusively closed. So on one hand, the IBAC is maintaining that for one reason or the other, inexplicable reason, they haven't explained to the court or to us how. They didn't make a mistake when they shut down the complaint. Everything was done properly, but on the other hand, they're maintaining that a complaint that was properly processed and dismissed can then be reopened at their own initiative without the complainant asking the body to reopen that complaint. I was the primary complainant. The complaint was also made for the benefit of Ms. Zhu. Neither Ms. Zhu nor I ever asked IBAC to reopen the complaint. We made a fresh complaint and asked IBAC to investigate that. What the IBAC did is reopened a complaint that was made in January. Now, that raises a number of conundrums, Your Honour, because the evidence that the IBAC considered had not been provided to the IBAC in relation to that complaint in the first place, which, by the way, is a breach of privacy laws as well, because I was the complainant and I had not authorized IBAC to use the evidence that I had provided in relation to a different complaint, albeit about the same people and common events. But I had not given them consent to use that evidence or information in relation to the first complaint. So they have reopened rather, and decided in favor of a complaint based on evidence that was not available when the complaint was live, and the only rational explanation for all of this is that they are trying to sabotage our misfeasance claim against them, of which they've been put on notice.
Yes, so with this proceeding, I think the main evidence, first of all, they are lodged in the form of affidavits. When we lodged the originating motion, I'm sure the court will not allow us to rely on that, so that will be the main evidence. So that's the complaint that was made to IBAC in January 2022. So with this part of the IBAC part of the proceeding, obviously one of the grounds is that in denying a cur, investigation, it could be, or it may be seen that it could be a denial of human rights to both of us. So for the court to determine that, the court must go through all of the evidence that's given to IBAC. So that will include the 4-hour audio recording. So otherwise the court will not be able to consider whether or not our human right or that IBAC's decision had affected the human rights point. What I'm saying is that that recording does not only have impact on as part of the IBAC proceeding, but also the obviously more importantly on the state of Victoria proceeding. And, perhaps, some of the LSD part. Kid. So if the court is going to, and the court must obviously in deciding this case on the current amended originating motion, then the court has to go through all the evidence so it can determine whether or not the human rights part have been affected. Would it be more sensible for us to have the other affected party back on and hear the evidence together, and let those party also have the opportunity to have a say? That will probably save the court's time because it doesn't have to listen to the same evidence again. And then obviously we don't want the court to make any findings or any comments without the State of Victoria party being here. And it happens to be that, the criminal proceedings have been finished. And
So what you say, just to make it clear. So what you're saying, the proceedings against the other defendants in this matter, so State of Victoria, Magistrates Court, Legal Services Court, they've been stayed.
Yeah.
And so what you're suggesting is that before this matter comes back on, those parties should also be participating rather than just proceeding against IBAC?
Yes. So last year, December, the 20th of December, when Justice Janine made this decision, it has I would say 99% of the rationale for my understanding is that His Honour is concerned that because the criminal proceeding was still on foot, but now it is not the case anymore. Obviously, both Mr. Cooksall and I have gone through quite a lot. We also had dealings with IBAC after the criminal proceeding has ended, had communication with them to, I think we have put some effort to have that part of the claim dealt with by ourselves, but it was not successful. So that, obviously, had taken some time. But if the court is to consider the evidence that we had put it from the beginning when the originating motion was lodged, so the audio recording and other statements made by us in this proceeding regarding the incident on the 6th of January 2022, then it would be more sensible for all the parties to be here, given that we will obviously bring the proceeding back on. And that court will not need to hear the matter twice, and obviously they will have an opportunity to give response or give that indistinct if they want to. That's one of the points for, adjourn an application. And the second point was for the adjournment application is, wait, give me 1 second.
Before you go to the next point, has there been any communication by you with the other parties after the 2nd of May 2021 about reinstating the merger?
Yes, Your Honour.
I think the first plaintiff has.
The first, yes.
I'm the first plaintiff.
Yes.
So I can confirm to the court that I have put everybody on notice of my intention to reinstate the proceedings. Your Honour, for the record, I just wish to point out that the orders that Justice Ginane had made are not binding on Your Honour. And I can give precedence about because there were orders, interlocutory orders that were made in these proceedings. They were not final orders, and especially because there was no issue estoppel arising from those orders. No facts were determined by His Honour. His Honour simply made discretionary orders in relation to the administration of the case. So those orders are not binding on Your Honour in any shape or form. And we say that there was an inherent dissonance of sorts in His Honour's decision in that the IBAC claims could not have proceeded without the court deciding whether or not the police had done something wrong in the event that IBAC and the plaintiff did not reach an agreement about whether or not the IBAC had done something wrong.
Mr. Cooksall, you don't need to go into that. I just wanted to know, my question was whether or not the parties had been communication. So that's been clarified.
Yes, but what I'm saying is that this matter should not proceed on its own.
Yes, I'm listening. I'm actually giving Emma Zizou an opportunity to...
Yeah, and I'm joining her.
Now I want to hear from her. Thanks, Ms. Zizou. So you finished that point and then you were going to take me to a second point.
Yes. So the second point is that given what Your Honour had in today's hearing mention, that IBAC have now obviously made a decision that's completely different from the decision that we are reviewing in this court or in this proceeding. So previously, when we were before judicial registrars, they raised objections in us putting those into evidence and say obviously, our intention is to say that given that they have first, what they have done is they have given the court an affidavit, I think March this year or February this year, to say that IBAC had decided to reassess the complaint that we are reviewing in this court. And after that, they did not inform the court what their reassessment outcome was. And in, I think, May or June this year we have received the outcome. And we want to use that outcome to say to the court that it is necessarily a concession made by IBAC, to say that the first decision, to say that there was some error or concession that they were wrong in the first place, or admission, yeah. So we want to use that to support our claim. Because otherwise, if it is a decision that was made that was a good decision-making process, then why else would you reverse it? And obviously, Your Honor would understand, because you probably make decision every day. If you have to, after 2 years, reverse your decision completely, then that would mean that you have conceded that the first decision was wrong. And in May or June, so previously, when we were before the judicial registrars, we wanted to have that decision, or have the court admitted those decision into evidence in support of our claim against IBAC, to say that they have committed an error in the first place. But they raised some technicalities to stop us from doing that, and the judicial registrars told us to raise it with the judge. So, and obviously I don't want to commit any offense, even though I don't think that will be. But I was being careful not to do too much, so that left me to come here to raise it with Your Honor. So my point is that if they can and they did not, then I ask the ability to use that new decision. Then, perhaps, it will lead to a different outcome. But I know now that they've decided to put that into evidence. And I think it just happened from the summons, and then they want to make it confidential. But obviously, I say that the new decision, that is completely different than the original one that we are reviewing, is the approach from our effort in litigating this matter. Because in the Chloe Armstrong affidavit that was put before Judicial Registrar Keith, she clearly said that after reviewing Justice Janane's decision, they have decided to reassess the matter. So it is, I say, only because we have taken this matter to court and have an interim judgment from Justice Janane that had led to a reassessment, and then an outcome that is completely different than the original one. So why can we not use it to say that they have conceded that they were wrong in the original decision?
If it's conceded they were wrong, why doesn't that bring the proceedings to an end?
Now,
Well, if that can be recorded, then we say they're wrong and we win, then I'm happy.
she's speaking for herself. But, Your Honor, there are 2 elements to the determination that the court has to make at this stage. The first element is whether the originating motion as it was originally filed has attained its purpose. And the second element is that even if you don't advance those claims further in this proceeding and bring a different proceeding for the misfeasance-related claims. The second element that the court has to decide in this proceeding is that the allegations that we have made about the IBAC abusing the judicial process, which I'm publishing everywhere, are now a public scandal. And the court has to determine whether or not what we're alleging against the Premier Anti-Corruption Agency is, in fact, true. Because,
I object to this, Your Honor. This is not the case that we have before the court at the moment.
No,
but,
It is a very confined case, which is, the parameters of which are set by an originating motion.
no, that's not true.
Mr. Cooksall has had many opportunities.
And I cite authority that the case is not confined by originating motion. It is to be decided for the facts that the court becomes aware of.
no,
I'm saying this was contempt of court. This is a different matter.
yes. Well, I'm not.
No, but if Your Honor,
No, sit down, please. Please sit down.
will I get an opportunity to address the court about this later? Because I'm not being heard. You don't know what I'm going to say and…
Mr. Cooksall, I am not going to hear you far and wide on matters that are not relevant to the things that I have to decide today. So could you please sit down, and I want to allow Mrs. Zhu to finish what she has to say. If she has finished what she had to say, then I will hear from the other side and then I'll come back to you.
If I might interrupt, Your Honor, and just say in terms of the amount of leeway Mr. Cooksall's been given, he's been given more than an hour to deal with an adjournment application.
Sorry, that's completely…
There's absolutely no basis to suggest that he hasn't been given a proper opportunity to be heard.
Yes. No.
No, but that's not what… No. The proper opportunity is not about how long someone is given.
Mr. Cooksall, I'm going to ask you to sit down so that I can finish hearing what Ms. Zhu has to say. And then, Mr. Brereton, I will come to you.
Thank you, Your Honor.
So, Ms. Zhu, was there any… They were the 2…
But I do have other things, Tar.
No, Mr. Cooksall, if you continue to interrupt, I am not going to be very happy about it. Mrs. Zhu.
Yes, I have. Yeah, so the second point is that because there was to me a threat of committing an offense if I use that. So that's why it has led to us until today before I can raise it. But, I'm glad Your Honor has raised it, so I'm happy to talk about it here.
But I think
That's why there seems to be some delay. But we say that because the concession is made. So for me, again, if they're happy to say, okay, there was an error or a concession made, then I'm happy with that. Obviously subject to her hearing Mr. Cooksall. And then the third point is the summons lodged by the IBAC.
the IBAC summons filed?
Yes.
Yes.
Which we haven't considered, Your Honor.
So it was…
They were lodged after the deadline set by the court.
Mr. Cooksall. Ms. Xu?
I think there are quite a lot of material there that I think we should be given an opportunity to respond, and before that summons is decided, we can't proceed to the trial anyway because it will have an impact on on the evidence that will be heard in court. And they've raised a lot of.
I don't think that's the case because I think, as far as I can see, there are a couple of things we have to decide. One is the adjournment, and then if no adjournment happens, then I would make a decision on the summons. But my understanding of the summons is that it's not that the evidence can't be given, it's about making sure that it's not made public. So, it can still be talked about by us, and I can hear it and I can see it, but it just can't be published. So I don't think it's really a procedural thing. It's not something of substance. So let's put that to one.
May I be heard about it?
No, I'm listening.
I wasn't heard about this, Your Honor. This is a new matter.
I'm not asking you about it, and we haven't got to that yet. I am responding to Ms. Kazu's third point on the adjournment, which is in relation to the summons. So I think before the trial proceeds, a decision would need to be made about that summons. Now, whether that happens today or some other time, but that's what you're saying to me, though, is that, I have to decide the summons before we can proceed with the trial.
Yes.
Well, I think that's right. I do have to do that. But I can do that today.
But we were not no notice for the summons, Your Honor.
What I say is we have.
The summons, Your Honor, if I may clarify.
No, Mr. Kuksal.
They were not part of the orders that Judicial Registrar Baker had made.
Mr. Kuksal, please sit down. I am listening to Ms. Zhu.
Okay, can you clarify that?
So it is a summons that we had no knowledge before. Obviously only after the November dates then we knew about it, and it is not just about the publication. I think there are some other restrictions that they want to put on.
All it is restricting the opportunity to look at that information to the parties and to the judge. And it just prevents it being circulated beyond the parties, you and me.
So we still should be given an opportunity to consider that. And they've raised submissions within the Public Interest Act that obviously, as self-represented litigants, we're not completely good with that. And
She's speaking for herself, Your Honor.
Yes. Sorry, I am not entirely familiar with that act. So whether or not our ability to talk about things will be affected, and other things, I think it will have an impact, and obviously I understand why IBAC wants to keep something secret, but to have something that's already been filed in public to now to be redacted or not be able to inspect it, or potentially, we can't say anything about them, then I think they would still be something that we might raise our objections or comments on. And unfortunately, I have been quite unavailable this month and I haven't been able to look at all the material that was filed by IBAC. So I think some time can be given to the plaintiffs given that we haven't completely considered the extensive material or things that's raised in that summons. I had a very brief look at it, Terioluf. And then the last point is not about the adjournment, but for filing the evidence. So I think the evidence that's being filed to our understanding was the affidavit that's already been repressed. Because I understand that Your Honor was just allocated to this matter, so it's not like if we file the court book with the same material that was already filed on request then a judge will look at it, because we don't know who will be going through those evidence. So I don't think that we're so to be blamed for that. The evidence was lodged. There were, they complain about how voluminous the material was, just lots of transcripts, lots of correspondence, there are multimedia files. There were files recorded in request, so I don't think that we should be kept from relying on that. And, again, because Your Honor was just allocated to this matter, so it's not like you can, go through them before it. So that's the adjournment application.
If I may clarify one matter about the summons, Your Honor.
No, we're going to come back the summons, and I was just going to say, Ms. Zhu, I think we're, perhaps, getting ahead of ourselves in terms of going into the substance of the summons. I took your point to be that the fact that the summons had been filed, that was another matter, which meant that you needed time, and one of the grounds for the adjournment. But the substance of it, I'm not going to, that's something that will have to be determined at some point. The point is, in terms of the rationale for that supporting application for an adjournment, is the fact of the summons. And it's something that you say you haven't turned your mind. So I accept that point. So in terms of what it might mean or not meant, I don't need to determine that now. But that will have to be determined at some point, prior to the trial actually commencing. So there's no need to go into the substance of it further, thank you.
Yes, Your Honor.
Mr. Brereton.
Thank you, Your Honor. Well, there's a lot there to deal with.
I'm not sure you have to deal with all of it.
I won't go through it all. I won't. I'll try and remain as focused. Mr. Kuksal just said the word, dishonest.
Dishonest? Yes, I did.
This sort of heckling from the bar table is entirely inappropriate.
It wasn't heckling, Your Honor. I was referring to my co-plaintiff who is familiar with Mr. Brereton's dishonesty. It's been alleged on affidavit.
Your Honor.
No, Mr. Kuksal. Mr. Kuksal, will you please sit down? Will you please sit down? You have had more than an adequate time this morning.
He brought this up. I was speaking with my co-plaintiff. He took offense at me.
Mr. Kuksal, please sit down. Otherwise, I'm going to have to ask you to leave the room.
This is most improper, Your Honor.
No, it's not.
I wasn't doing anything. I was speaking with my co-plaintiff.
Please sit down, and I'll ask you not to interrupt Mr. Brereton.
I was not interrupting anybody. I was speaking with my co-plaintiff.
I'm an officer of this court. This proceeding is being not only recorded but also live-streamed. It is a very significant issue for somebody in Mr. Cooksal's position to make statements of that nature in a public forum.
I have made them all in affidavit.
It is highly inappropriate.
Why have you not?
Mr. Kuksal, I'll ask you to be quiet, please, otherwise I will have to ask you.
Your Honor, my reputation is also at stake. This is a publicized proceeding. He's implying that.
Mr. Kuksal, would you please sit down and be quiet so I can...
May I just raise this?
No.
For the sake of the recording.
No, I'll ask you to please sit down, otherwise I'm going to have to ask you to leave the room.
Okay, but I'm not just raising that allegation as an offhand remark. I am putting that allegation in evidence.
No, Mr. Kuksal. I have...
No, that's a matter of fact in this proceeding.
Mr. Kuksal, I am asking you to please restrain yourself.
I am restrained, Your Honor.
And I will ask, and this proceeding I need to deal with these preliminary matters as quickly as possible. And the constant interruption and noise from the bar table.
Your Honor, I will not accept that he acts in a matter that pretends to be scrupulous or conscientious. I consider that to be an offense to my intelligence or my ability to protest at that blatant dishonesty. I will not accept.
Your Honor, he should be removed from the court. This is outrageous.
No, Mr. Kuksal, I'd ask you to please sit down. I understand you're quite agitated about it.
Yes.
But this does not assist. And it is...
I'm not disagreeing with Your Honor.
Okay. Please, sit down.
Thank you.
And I do not want to hear from you until I ask you, till I call upon you.
Yes.
Thank you.
But if he doesn't complain about me, that's...
Mr. Kuksal will sit quietly and listen to what he has to say, and then you'll get an opportunity to respond. Thanks, Mr. Brereton.
Just for the record, if I'm heckled again, I will continue to raise it because it is completely inappropriate. Mr. Kuksal.
And that I will point out his dishonesty.
He should be removed, Your Honor. This is outrageous.
Mr. Kuksal, this is most inappropriate.
Your Honor, he interrupted me when I was...
Well, he was making an objection.
I'm objecting to the fact that he's implying that I'm raising these allegations facetiously. He's implying, fundamentally, that I have no proper basis to have those Your Honor, the barrister's conduct proves, action suggests.
No, sit down. Mr. Kuksal, please sit down. Please sit down. I am not going to...
I'm making a legal submission now.
I am not, no. You have gone on long enough about this particular topic. I've asked you...
He's implying that I'm acting improperly. He's asking the court to kick me out.
No, I am asking you to please sit down and be quiet while I hear Mr. Brereton.
And I have no problem with what Your Honor's saying. I have a problem with what he suggests.
And I will know. If you don't sit down and allow Mr. Brereton to make his submissions, I will ask you to leave the courtroom.
I have always sit down when Your Honor asked me to sit down.
Please, sit down, and I'll ask you not to interrupt.
He's deliberately provoking me, Your Honor.
Mr. Kuksal, I've just given you a direction to please not interrupt so I can hear from Mr. Brereton. Now, Mr. Brennan, I hear what you have to say about the interruption. Mr. Kuksal is on his last warning in terms of interruption, and I do intend to, as expeditiously as possible, deal with the submissions you have to make, in response to the adjournment. I will ask you whilst a lot has been said by Mr. Kuksal this morning, which is not relevant in my view, to what we have to determine today, and has traversed matters which are not helpful. I would ask you to address me on the substance of the response to the adjournment application. And it does seem to me that the primary question or the primary proposition that's been put is that there has been sufficient time, because of other proceedings, to get to where we were at today. But I don't want to stop you from addressing me on the matters that you wish to raise in terms of the response.
And I understand that, Your Honor. And I appreciate that indication. The issue you will, I'm sure, understand, however, is that as I've mentioned before, if there are certain things said in a public forum of which this is, I'm an officer of this court who relies on their reputation and for whom reputation is extremely important. There was nothing that I had even said, no words had come out of my mouth which could have even justified what Mr. Kuksal said in a way which was clearly audible, clearly designed to be broadcast to the world at large.
Sorry, Your Honor, I take objection to that.
He knows that the Zoom link is in play.
Your Honor, I have on objection. He's speaking to my intention now.
Mr. Kuksal.
I object to that, Your Honor.
In those circumstances it was appropriate for me to take issue with that. On my submission, we are quickly approaching the point at which the interests of justice are likely to be affected by Mr. Cooksall continuing to be permitted to sit at the bar table. It may well be.
Your Honor, sorry, I take objection to that. He's attacking me in a public forum.
Mr. Cooksall,
This is completely irrelevant.
Mr. Cooksall, I have warned you not to interrupt.
I'm making an objection. He's attacking me in a televised hearing.
Mr. Cooksall, I am going to ask you to please sit down.
Your Honor,
I am asking you to sit down, please.
could Your Honor determine my objection?
I have heard what you have to say, and he is getting an opportunity to respond to the vast allegations that you have made this morning, and I am going to give him that opportunity. And as he did not, given the hour or more that you were able to address was very moderate in taking the minimum objection, I am going to ask you to sit and hear what he has to say, so he has an opportunity to address what you have said without objection.
Okay.
And to finish the point I was making, it may well be that we're quickly reaching a stage where the court has to find a different way to have Mr. Cooksall's position put before the court. It might well be that, for example, requiring written submissions and things of that nature are an appropriate manner to deal with this. Because, to be frank, having sat here and listened to what Mr. Cooksall has said for such a long period of time in relation to such a confined and narrow originating motion is an abhorrent waste of the court's time, with all due respect to everybody involved. Insofar as the adjournment application is concerned, I think this is the latest in a string of what is properly characterized as attempts by the plaintiffs in this case to abuse the court's process.
Sorry, Your Honor.
The court has given so.
I object to that. I object to that. There is no evidence that.
I'm about to go to it.
Mr. Cooksall, enough. Please, sit down.
So I'm glad Mr. Cooksall raised the evidence.
We are not.
Because I'm about to. The court has given the plaintiffs in this case an extraordinary level of indulgence to state what, precisely, their case is.
We have.
There is a standard operating procedure, for want of a better term, engaged in by the plaintiffs where when they're given those opportunities, they just ignore it, and instead show up like they have this morning and make submissions without notice. Now, the latest example of that, of course, Your Honor, is the extent to which, about a week ago, the possibility of seeking to adjourn the proceeding this morning was raised by the plaintiffs. And the court's registry diligently advised all of the parties that if there was going to be an adjournment application there would need to be a summons and there would need to be affidavit material, and it would need to be done in the ordinary way. Now, nothing you've heard from either Ms. Zhu or Mr. Cooksall has addressed the extent to which there's been, not even an attempt to comply with the court's direction in relation to that. And of course, the court gives those directions to make sure that things can be done efficiently and expeditiously. But of course, that is not the only example in this particular proceeding. And if one traces back through the history of the opportunities that the plaintiffs have been given to not just take particular procedural steps along the way, but more fundamentally, crystallize or clarify what their case is. Now, one of the example of that was when, or is referred to in Justice Jinan's reasons from December of last year, when, at that time, in deciding that the plaintiffs may have an arguable because it appeared to Justice Jinan that IBAC may not have considered the complete parameters of the matters that were being complained about. Just for the transcript, that statement is at 151 of that judgment. In the course of that proceeding, Mr. Cooksall, having spent considerable time reading the transcript, made a range of very similar allegations to what have been made this morning, and he was given leave to amend what, at that time, was the originating motion which had commenced this proceeding. Now, as Your Honor has sought to unpack with Ms. Zhu and Mr. Cooksall, at the time that the originating motion was first filed, it was an originating motion which brought a proceeding not just against my client, the fourth defendant, but the state of Victoria, the Magistrates' Court, and one other defendant that just escapes me.
The Legal Services Board.
But the effect of the opportunity that Justice Jinan gave the plaintiffs to amend was, in the context of the stay which had been granted, to effectively excise the part of the case which related to IBAC from the proceedings more generally. Of course, that was an entirely appropriate thing to do, because at the time, and still to this day, according to the originating motion insofar as the plaintiffs and IBAC is concerned, relates to a decision which, as Mr. Cooksall quite rightly pointed out, was made in April 2022. IBAC has no involvement in the other issues that Mr. Cooksall raises against the other parties. It would be highly inappropriate, highly inefficient and, with respect, contrary to, plainly, the decision and the approach Justice Jinan took to grant an adjournment to then essentially have this proceeding be folded back in with any proceeding which might now be undertaken against the state of Victoria and others if and when that stay is lifted. I should say in respect of that stay, from my perspective I don't have any instructions to say that there is any basis upon which that stay could be lifted. As far as I know, based on the evidence, the criminal charges which appear from the judgment to have been the basis upon which the stay was granted, may be in some position which will continue to mean that the stay is an appropriate step to take.
Sorry, I take objection to that, Your Honor. It is before His Honor in his later judgment this year, has acknowledged that the charges have been withdrawn. The IBAC should have a copy of that judgment.
Yes, okay.
This is dishonesty.
No.
No, this is dishonesty. Does the published judgment of Justice Ginane?
Sit down, Mr. Kuksal. I am asking you again to sit down.
Could you look into the matter, please?
No, sit down please, and allow Mr. Brereton to complete his submissions, otherwise I am going to have to ask you to leave the courtroom.
I am simply noting that.
It's noted.
Thank you.
I think, for the record, that's about the 6th time Mr. Kuksal has called me dishonest, with absolutely no basis whatsoever.
Sorry, Your Honor, I object to that.
No, Mr. Kuksal.
There was an allegation made against me.
No, Mr. Kuksal, I heard what you had to say and it's not.
And I clarified the basis.
And I am asking you to sit down, and I want to.
It was alleged against me, Your Honor.
Mr. Kuksal, I am going to ask you to leave this courtroom. Leave this courtroom, please.
Are you removing me from the courtroom?
I am removing you.
Okay.
So that Mr. Brereton can continue. Mrs. Goose is here.
She is not acting for me.
She is able to participate.
She is not. Her English is not her first language, and I do not.
Mr. Kuksal, look, I am asking you to leave the courtroom.
That's fine, but I am noting for the record that this gives rise to reasonable apprehension of bias, and I will be making an application for Your Honor's recusal.
Okay. I am going to ask you to leave. You can remain within the court precinct, but I am just asking you to leave for at least what time is it? Unless you give me an undertaking that you will not interrupt for the balance of Mr. Brereton's submission, I am going to ask you to leave and sit outside the courtroom.
I raised a proper objection to an allegation that was made against me.
No, you did not. It is not a proper objection and your behavior is offensive. I do not believe that this is an appropriate way to conduct oneself in my courtroom, and I need to be able to hear what Mr. Brereton has to say. And constant allegations of dishonesty that you make from the bar table is impeding the proper progress of this matter.
Your Honor, I simply pointed out that the assertion that I had made an allegation without proper basis was unfounded because I had identified the basis upon which I was making the allegation.
Mr. Kuksal, please sit down.
Thank you.
Mr. Kuksal, please sit down.
Would you apply the same to him? If Your Honor cannot expect me to quietly listen to someone.
No, Mr. Brereton has not, at any time, accused you of dishonesty. That is not what has been said against him. No, it's not what the essence might be or how you might read it. I am listening to what he has to say.
Okay.
And you cannot accuse a member of council who is doing his job of dishonesty just because you take a different view about what he has to say. It is inappropriate behavior in my courtroom.
To clarify, he said that he was unaware that the charges had been withdrawn.
No, Mr. Kuksal, that is not what he said. Please sit down, and I want to hear further from Mr. Brereton.
Well, I wish I had some real-time transcript, Your Honor, but my recollection of what I said is that I don't know the status of that criminal proceeding, so I don't know whether it is appropriate that the stay is still in place or not.
Exactly.
Now, Mr. Kuksal says the charges are withdrawn and he points to a judgment from Justice Ginane.
Yes.
Now.
Your Honor.
But that's not to say that there's no other charges, for example, or another.
I object.
No, hang on.
I had discussed it with them.
Mr. Kuksal, please do not interrupt.
May I object?
No, this has become quite unworkable and it is not of assistance to me, and not of assistance to this court in getting on with things. Now, if you cannot behave yourself, my only option is to remove you from the courtroom.
No, I simply want to point out to Your Honor.
No.
Okay.
Mr. Brereton.
Thank you, Your Honor. So I think I was talking about the indulgences that the court has given over the. I take the point that in terms of the basis of Justice Ginane's stay, no action has been taken further in relation to that. I asked the question of Ms. Zhu about whether there had been any communication with the other parties. I am assuming you do not act for them. I do not.
And there is nothing on the court record that I can find of communication about brining on proceedings that had been previously stayed. So the only question I wanted that I had asked was had there been any notice or communication. That has been answered. At the moment, all I have before me is the originating motions, the allegations made against your client.
Yes.
And that is the only trial which is currently extant for the court.
Indeed. And the point I was making was that there is very good reason why the confined originating motion that currently exists, that is currently before the court, should remain before the court separate from any other proceeding that might, in the future, occur in relation to those other defendants. And the issues that I was pointing to in that regard were the rationale of Justice Ginane's reasons in terms of why he allowed amendment of the originating motion by the plaintiffs to deal just with its claim against IBAC, which is of course what the court has before it for the purpose of the trial that is being listed today. So that deals with that. In terms of the broader issue of the multitude of things that have been raised, Mr. Kuxel is probably going to find what I am about to say next provocative, but under cover of noting that, on my submission, the way this morning has played out, and the things that have been said is just the latest example of the extent to which the plaintiffs are attempting to use this proceeding to abuse the court's process.
I object to that.
No, sit down.
I simply wish to point out that Ms. Zhu is not engaging in the conduct.
Now, that leads me to the point of saying Mr. Kuxel has been given every opportunity to state what his case is, do it in a way which gives the proper opportunity to consider it. The court should approach submissions that an adjournment is necessary today without material and in the context of what I've taken the court to, with significant suspicion. It should treat the application as an attempt to further abuse the process of the court. Now it's, of course, a very serious thing for me to suggest that what the court has before it is an instance of an abusive process. And it's not a submission that, of course, is made lightly. But it is a submission that is made having regard to what the law says about when the court can properly find that there is an abusive process. And in relation to that particular issue, in our written submissions, which Your Honour will have no doubt read before coming on the bench, we refer to the High Court Authority of Batistados versus the Road and Traffic Authority of New South Wales, 2006, 226 CLR 256, at 265. In particular, paragraph 9, Chief Justice Gleeson and Justices Gummow, Hayne and Crennan. And I'm paraphrasing here, but it's well accepted that what constitutes an abusive process is insusceptible to formulation comprising closed categories. But, I think, relevant to what the court has before it at the moment, it is accepted that it's beyond doubt that an abuse will usually occur where the court's processes are invoked for an illegitimate or collateral purpose. Now, on the basis of what both Ms. Zhu and Mr. Kuxel have said this morning, they are clearly attempting to invoke the court's process, insofar as it relates to this originating motion, for an illegitimate or collateral purpose. And I come back to Mr. Kuxel's statement about him seeking to have the court hold the government to account. That's not this court's job in this instance. This court's job in this instance is to hear this originating motion and determine whether there's a jurisdictional error or an error of law. The use of the court, there's the second aspect of the abuse which is engaged, on my submission, in this instance, is the use of the court's procedures is unjustifiably oppressive to a party. Now, it might be said against that it relies on acts of government instrumentality. However, there comes a point at which funding myself, Ms. Armstrong, our instructing solicitors from DLA Piper, requiring my instructing solicitors from IBAC itself to attend court constantly, including on the 4 or 5 examples that I've taken you to, there comes a point where we're doing our best to try and engage with the plaintiffs and hearing nothing, except dealing with attempts at ambush, which is what's happened this morning, constitutes an instance, even with a government department like the one I represent, that the court's procedures are being used in a manner which is unjustifiably oppressive to a party. And on my submission we are in that territory, and that should be a basis from which the adjournment application should be denied as well. The other aspect of the abuse which is well-founded, and this is drawn on cases such as Brown v. Corrections Victoria, which although is a decision from an Associate Justice Haji, 2022, VSC 217 at paragraph 26. It's a decision which cites, I think, uncontroversial law in the form of the High Court's decision in Rogers v. the Queen 1994-181 C.L.R. 251, at 286, per Justice McHugh, among other High Court decisions, I should say. And the proposition is that an abuse arises where the use of the court's procedures would bring the administration of justice into disrepute. Now, that arises, in this instance, on several bases. The time and resources the court is devoting to what is a very confined issue, which, on my submission, is an issue which is capable of being determined on the papers. There are no witnesses. There is no evidence. I beg your pardon. There are no witnesses. To the extent that there is evidence, that evidence is evidence which is capable of being tendered absent a witness. So we're in the territory where we have business records, for example, which can be tendered in the usual course. It's actually not necessary in this case for the court to hear orally from the parties, necessarily. It's a matter which could be dealt with on the papers. And, in fact, given the confined nature of it, in my respectful submission, probably is a matter that should have been dealt with on the papers. However, be that as it may, we are, as I say, based on all of those issues that I've just raised, in a position where the use of the court's procedures are definitely bringing the administration of justice in disrepute. And, of course, the relevance of whether or not there's a different way to give Mr. Kuxel the ability to be heard is of particular relevance in this instance. Because, as Mr. Kuxel has demonstrated from his behavior this morning, he is incapable, absolutely incapable of controlling himself. He has alleged against myself, as a member of council who has an impeccable record in this business over 20 years, without evidence, in a public forum that I am in some way dishonest. That is an example of the court's procedures being used in a way to bring the administration of justice into disrepute. In all of those circumstances, Your Honor, we object to the adjournment application. We seek to have the summons heard and then the trial proceed in the ordinary way. And if you can just excuse me for one moment, Your Honor. The other thing which, thank you to Ms. Armstrong, I forgot to mention was the extent to which Ms. Zhu had talked about the service of the summons in relation to the orders we seek about the application of Part 7 of the Public Interest Disclosures Act, and the question of whether or not that could provide a basis upon which an adjournment should be granted. On that issue, that summons was served on the plaintiffs on the 1st of November 2024. As I said, it wasn't served in a vacuum. It was served in circumstances where we previously identified the potential relevance of Part 7 of the PID Act, and we'd invited the plaintiffs to engage with us on the issue of whether or not they thought Part 7 of the PID Act was engaged, and if so, what should be done about it. But even if we hadn't done that, having served that summons on the 1st of November 2024, the plaintiffs have had 14 days between service and today to raise issues in relation to that. And, in particular, as I said earlier, they've been given the opportunity by the court to put on their own summons and material which seeks an adjournment. Now, when that request was made to the court and the court came back, one might have expected it's very easy to put on a summons which says, well, we need an adjournment because we don't understand what Part 7 means, and we need to have that clarified for us. That doesn't take an enormous amount of work. And there's no explanation as to why that couldn't have happened, particularly when the direction was given by the court to that effect. So in all of that, Your Honor, on my submission there is no proper basis upon which the summons should not proceed and the trial of the proceedings should not proceed today in the ordinary way. If the court pleases.
Thank you, Mr. Kuxol.
Now, Your Honor, I'm going to need some time to address each of the matters that I have patiently listened to the best of my capacity. But this is the most important thing that Your Honor needs to take from this. When Your Honor arrived this morning in introducing what Your Honor knew or understood about the matter, Your Honor clarified that Your Honor had gone through some material and understood very well what our case was. Mr. Brereton has repeatedly said some very contradicting things in that he has clarified his perfect understanding of what the matter is, whilst at the same time alleging that the manner in which we're putting matters to the court is unintelligible.
I don't think he said that.
Well, Your Honor, I think Your Honor is more capable of understanding what is saying than his words would indicate. But the transcript will show that he has alleged, repeatedly, that we are not clarifying what our case is, whilst also alleging that our case is very well defined and very short compass. Now, the sleight of hand that's involved in reconciling those two things is that what is saying is that every matter that I raised as a complaint or a protest is a matter that necessarily needs to be decided in the context of the originating motion and is a matter that ought to be pleaded in the originating motion. Now, firstly, there is no basis for asserting that we are continuously adding new things to the matter. And if I raise a complaint about what I experienced, that is for simply the benefit of the transcript. I run a not-for-profit and part of its objective is to hold government bodies to account. And I intend to use the transcripts of these proceedings and what is discovered, if it is in the public interest, for the public interest.
Mr. Kuxol, how is this responsive to the submissions?
It is.
Well, it's…
Your Honor, you're being very impatient with me. You're not letting me complete.
Mr. Kuxol, I am far from impatient with you. But I do expect…
Well, you would think so, but
I do expect you to address matters of relevance of…
You let him go on, Your Honor. You did not ask him where he was going.
No, do not even suggest that, Mr. Kuxol.
I am suggesting that.
No, I have asked you.
You didn't know where he was going.
I have asked you to reply to the matters that he has raised.
And I am replying to them, but you're stopping me halfway through my responses. What I'm saying.
Because it's non-responsive to the matters that he has raised. There are 3 matters.
Your Honor, the points I'm making are very technical and they're deep.
They are not technical points.
Yes, they are.
No, Mr. Kuxol.
May I just complete what I was saying?
No, you cannot. Move on to the next point.
No, Your Honor. I will complete what?
No. Well, I am not going to hear you any further if you cannot comply with my direction.
Sorry, I will have to raise a recusal application then, Your Honor.
Mr. Kuxol, I am going to adjourn the court now. I am going to make arrangements for you to participate in this hearing from outside this courtroom if you cannot behave.
Okay, first, you should hear my recusal application then.
No, I'm not going to hear your recusal application. I'm going to adjourn for the luncheon adjournment, and we will return at 2 p.m. I would like you both to give some consideration to the manner in which the trial can proceed, if it can proceed by way of written submissions.
No, it cannot proceed that way.
As an alternative. Thank you.
Your Honor, I don't know if it's too presumptuous for me to go first.
Sorry, I was in the middle of submission.
No, I'm going to ask what he wishes to raise. Mr. Brereton.
You did ask the question, I think, before lunch, as to the options for the way things should proceed.
Yes.
Sorry, Your Honor, there's.
Mr. Cooksall may want to go first, which is totally fine by me.
That's okay. Have you given it some consideration?
We've given it some consideration. We have.
I wasn't done responding to his matters, Your Honor.
Mr. Cooksall, your behavior and demeanor is really quite unacceptable,
Your Honor.
and I'm trying to run a dignified courtroom here. And your constant interruptions do not assist. Now yes, I am aware that you haven't completed what you had to say. I did raise just before I rose before lunch, that I wanted people to give consideration to that. Now Mr. Brereton's just raised that with me, he's raised it. There's no particular issue about it, you don't have to argue every single point.
Okay, Your Honor, this is most improper. What Your Honor is saying can only be justified if one removes the context of these proceedings from my conduct. I was thrown in jail.
Mr. Cooksall, I am not going to hear you any further in relation to this.
Well,
No, you are going no.
I want to make a recusal application. No, I want to make a recusal application.
No, please sit down. No.
You are harming my reputation in this matter.
No, Mr. Cooksall, please be quiet. If you wish to make a recusal application, by all means you can do it in writing by 4 p.m. tomorrow.
No, I have a right to make it.
No, you do not have a right to do it in the manner which you...
I do. I would like to be heard about the right to make the application orally.
I have made my ruling. If you wish to make a...
You didn't hear me about that.
You've said you wish?
You didn't even give me an opportunity to be heard.
Mr. Cooksall, if you cannot respond appropriately, then you will have to leave this courtroom. I am...
Okay, Your Honor, I'm starting to get an idea that Your Honor has an agenda to push.
I beg your pardon, Mr. Cooksall. That is the most inappropriate allegation to have made.
It's not.
If you wish to make a recusal application, you can make it in writing.
You did not hear me about.
In writing by 4 p.m. tomorrow.
Okay, I am saying.
I have made that direction.
Yes, and I wish to be heard about that.
No, I have made that direction. End of story. Now move on.
So what I'm saying is that it's to me, Your Honor has pre-decided that you will dismiss the application.
No, that is not the case.
Because you're not listening to me about.
I have listened to you for far too long this morning.
No, see, again.
On matters which are not relevant to the issues which are in dispute in relation to the adjournment application. We have set this down for a...
No, I have a, Your Honor, in the Judicial Commission.
No, Mr. Cooksall, if you are unable or unwilling to respond to the directions that I have made, then I will have to remove you from the hearing. You can sit outside.
I'm not going to be threatened by that like this.
No.
No, I don't respond to threats like that. I have a clear and...
Mr. Cooksall, I am going to adjourn this. I am going to adjourn the hearing for 5 minutes while I make some inquiries as to what further steps can be taken in order to continue this hearing. Mr. Brereton?
Can I just assist by saying this? I understand that Justice Gordon has made arrangements in other litigation Mr. Cooksall's involved in, whereby he...
No, he hasn't. He's not, Your Honor.
No, I've made some inquiries about finding...
So, 2024, VSC 674 at paragraph 25, Justice Gordon refers to the extent to which he's had Mr. Cooksall removed from the court so he can observe it.
Okay, Your Honor, I'd like to.
I have made inquiries over lunch, given the proceedings the way they proceeded this morning. And you have access to a computer and the live stream. You can sit outside the courtroom, and when it's your...
I will not.
When it's your opportunity to respond, I'll bring you back into the court.
Your Honor knows that His Honor's conduct is the subject of a public petition.
No, I am not going to listen any more about what just...
Okay, I will need to add Your Honor's conduct to the same petition to raise those matters in.
I will not listen to you further about Justice Gordon. That is not a matter that I'm taking into consideration. I am running my own...
You have said that you have taken it into consideration.
I am making my own judgment.
You said you made inquiries. You didn't check with me.
I beg your pardon, Mr. Cooksall. How dare you speak to me in that tone? I said that I have made some inquiries as to what are the measures that I could...
In light of my behavior earlier this morning.
Yes.
Yes, that's improper.
Because 17 times I have asked you to either be quiet or sit down.
Yeah, Your Honor.
This is behavior which is totally unacceptable in a courtroom. Totally unacceptable.
You're not letting me speak. What you are trying to do is create a narrative here, and you are divorcing.
No, I have...
No, I am deeply traumatized by what has happened to me. And I am aware of the manner in which people are acting dishonestly in this matter. I am intimately aware of it, and it is at my expense and the expense of people that are dear to me. Your Honor, for Your Honor to come here and without empathy.
Mr. Kuxel, you will sit down. You will sit down.
Your Honor, he just made a very inappropriate sound.
Come on, Mr. Kuxel. Mr. Kuxel, I am.
This is disparaging behavior. I mean, the number of times I was checked for speaking with my colleague or for there's clearly a disparity in the manner in which Your Honor.
I am going to stand this matter down. It's quite clear that, Mr. Kuxel, you are not either capable or willing to listen to my directions. I'm going to stand the matter down for a few moments and I will come back at 2:15, and then we'll resume the matter. I have directed that if you wish to make a recusal application, you can do so in writing by 4 p.m. tomorrow.
And I wish to be heard about that.
And other than that, unless you have anything responsive to what Mr. Brereton has said in relation to the adjournment application, we will deal with the adjournment application on my return. Just adjourn until 2:15. Mr. Kuxel, is there anything further you wish to say in response that hasn't already been referred to in relation to the adjournment?
I haven't had an opportunity to respond to Mr. Brereton's various submissions. But I will just note that what happened this afternoon shows the extent to which Justice Gorton is perverting the course of justice in other proceedings. And I intend to raise this matter in relation to the petition that I'm making to Parliament. And I'll leave it at that. I also note for the record that I think Your Honor had an obligation to first hear me about any prejudice I may suffer as a self-represented litigant or my capacity to make written submissions by the deadline. Your Honor clearly contemplated how she could contain me, or you could contain me, and came out with a judgment that you had decided without giving any consideration or asking me about those matters. And the relevant authority is Matsukatidu v. Yarra Valley Rangers, where Justice Bell has laid out in great detail matters including the personal, sometimes visceral feelings that self-represented litigants have on account of their emotional investment in the matter. And it is not a matter for which they should be penalized. His Honor also gave a similar judgment.
Yes, okay. I'm aware of that case, Mr. Kuxel.
I'm noting this for the record, Your Honor. I should, because the Court of the Appeal.
I hear what you say. It's on the record. Now, move on, please.
No, but let me name the authority.
No.
One authority will not take that much time.
Mr. Kuxel, we have
Tomasevich v. Tonlovich. It's another authority by Justice Bell.
Mr. Kuxel, I've asked you to move on.
Yep.
I've recorded what you've said. I've recorded the name of the case. I'm well aware of it.
Would you like the citation?
I know the case.
Okay.
And I'm well aware of the obligations on both the self-represented litigant and the system. So can you please move to
The only instance in which I could have been definitively acting improperly was if I was acting dishonestly.
Mr. Kuxel?
That's a fact.
Mr. Kuxel, you are
If I were genuinely affected emotionally.
Mr. Kuxel, this is not responsive to any of the matters that we have raised this afternoon.
I am going to respond to that, but I'm just clarifying.
Okay, can you move on? You are wasting far too much time.
No,
You are wasting far too much time, and I am going to ask you to directly address any points that haven't already been raised in response to the adjournment application. And if you won't do that, I will rule on the adjournment application and we can then move to whatever we have to do next.
Okay, respectfully, I'm only raising indistinct if you have an agenda. Now, in response to what Mr. Brereton said, there's a number of points that he made and I wish to address them. The first point, perhaps the most significant one, was this incoherent argument about the proceeding being an abuse of process. Because the originating motion as it was drafted is more limited than what he thinks that we will pursue in this matter. To clarify to the court and to the other parties, we do not intend to bring the additional matters that we had initially anticipated we would bring in this matter. When Mr. Brereton alleged to the court that we had sought to amend the originating motion and then did not take up that opportunity, he was being misrepresented in the sense that we had already told the IBAC at the time that we have decided not to add those matters in this proceeding and to start a separate proceeding against the IBAC. This was also discussed in front of Judicial Registrar McCann. What was discussed was that we could either bring those claims in this proceeding or via a separate proceeding. And Her Honor gave us the opportunity to bring them in this proceeding because we had wanted to keep that option open. So,
have you done it or haven't you done it?
No, because we're bringing a separate proceeding in relation.
Okay, all right, move on. Okay, next point.
No, but I have to correct that. Please do not.
You've just corrected it, so move on.
Yes, but I don't like the tone, Your Honor. I don't like the gestures. You're being very aggressive with me.
I am not. Mr. Kuxel, we are spending a lot of time getting to the point, so can you move on? You've made that point, let's move to the next point.
No, but I do not appreciate the way in which you're treating me.
Mr. Kuxel, if you...
I'm entitled to some self-dignity. I understand that you think that I'm not being as efficient as you would like me to be.
No, you're not being responsive.
But that's no reason to be condescending towards me.
No, you're not being responsive.
I'm entitled to complain, Your Honor. I'm entitled to, you're a public official. I am complaining about your conduct. You cannot be offended.
Mr. Kuksal, you are being offensive.
No, I called you condescending because I thought you.
You're not being responsive. You are not being responsive to my direction.
I am. I've responded to.
Can you please move on to the next point?
Okay.
And don't argue with me about the process, just get with them. Get on with the subject.
Your Honor, I am a sensitive person. I do not.
Mr. Kuksal, don't keep speaking over me. That is most inappropriate.
I'm sorry.
So can you please go to the next point?
Okay, so the point is that the scope of these proceedings, firstly, is the determination of the initial error that we say is a matter of admitted fact in the proceeding by the fact that the decision has been reversed now, the IBAC decision. So the original decision was to dismiss the public interest, was to dismiss the complaint.
How is this responsive to the argument about an adjournment? This is about the summons.
It is. Yeah, let me clarify that. What is being said is that we are engaging in an abusive process and that this proceeding is unwieldy. It's directionless. We don't know what we are doing with the matter. I'm clarifying to the court that we know precisely what we're doing, and that is, 1, to get a determination by the court, an affirmation that what is clearly evident has happened. Secondly, the matters that have arisen after that which will be relevant to matters like the cost in the matter, whether or not the time that was spent was on account of something that we did wrong, or whether the representations that have been made about us being tardy, irresponsible and the like, we should be able to clarify that on the evidence. So what we're saying is that, primarily, what the court needs to decide is those two things in this proceeding. The jurisdictional error issues and, beyond that, the only matters that will be relevant is the conduct of the parties. There's nothing improper about that. Now, we're not wanting to lodge a fresh originating motion. We're not wanting to expand. We don't have any ulterior motive with respect to causing delay. We want this matter to be indistinct as quickly as possible. And for the record, we have sought reasons from IBAC for its decisions. We've still not received any. That is also in evidence. So that was the first matter. To argue that we are engaging in an abusive process is hopeless because we are not trying to extend these proceedings in any way. All we're saying today is that the summons, which Mr. Brereton says was served on us 2 weeks ago, I'm not contesting that because I don't know exactly, I didn't check when it was served. But even if it was served 2 weeks ago, there is no law that says that within 2 weeks we have to be ready without a court order requiring us. And a court order would not be made before hearing from us about our capacity to be ready. That's the first matter. The second matter is that Mr. Brereton has repeatedly that it is not the job of the court to hold the government to account.
What? I did not say that. At no point have I said anything to that effect.
Yes, look, Mr. Brereton.
Your Honor, he didn't let me complete, but he did exactly say that. And then he qualified it by saying, in this proceeding.
Well, that's directly responsive to the allegation you made, So you say that, he says that.
I'm saying it cannot be reasonably argued that the job of the court is to hold the executive to account.
Yes, okay. So move on. Next.
No, I'm just clarifying the authorities in this respect because as I said.
You don't need to. You don't.
No, I have to, Your Honor.
No, you do not.
I have the right.
I am telling you, you don't have to. I understand the point and I accept the point that the role of the court in judicial review matters is not broadly the whole.
But this is not the judicial review matter.
But in administrative review matters like you have brought, there is a confined.
This is an equity matter as well. We're relying on declaratory relief. And it's a constitutional matter as well. We're relying on the.
But what you're saying in terms, well anyway, let's move on. Next point.
It's a fine point. But, Your Honor, the reason I make the distinction is because judicial review is more limited in scope.
Okay, next point.
Now, I referred to Van der Lee versus this, an authority that we've cited to the IBAC repeatedly in relation to what it has mischaracterized as the scope of proceedings. Van der Lee v. New South Wales, State of New South Wales and Ors. Citation is 2002 NSWCA 286. It cites a number of preeminent titled authorities including Walton v. Gardiner, Williams v. Sports. The authority that Mr. Brereton cited, Batistatos, the only way he could have relied on that was if he could confidently think that Your Honor would not actually check the authority in detail. Because I am familiar with that authority intimately, like some 38,000 other authorities that I have familiarized myself with the last 3 years. The law in respect of abusive process is not whether or not the parties have the right motive or the right intention, it is simply whether or not the relief that they're seeking is achievable at law and whether granting that relief would cause some other greater injustice or harm to the public interest. The second criteria is extremely hard to satisfy, especially for an agency that has been accused of corruption whilst holding the purview of regulation corruption among all other government agencies in the state. So in Van der Lee v. the State of New South Wales in particular, it was discussed at great length whether or not a litigation which would otherwise not have been continued but for another ulterior benefit becomes an abuse of process. Because the ulterior benefit may be substantially driving the outcome. I am not saying that that is the case here, but I am saying that is how extremely it goes. So long as the person has a legitimate claim that is pursuable at law, the proceeding cannot be an abuse of process. This court is also bound by the Supreme Court Act, which obliges this court to determine matters of fact in accordance with the law under the declaratory relief provisions without consideration of whether or not any material benefit may be gained. In Ainsworth v. Judicial Commission, I am just getting the citation. Okay, so AINSWORTH vs Criminal Justice Commission 1992, HCA 10. In that particular authority it was found that the ultimate purpose of the court is to do justice. If someone has been wronged and there is no other way of delivering justice to them, then the least the court can do is make a declaration about the truth of the matter, especially in cases where someone's reputation has been harmed. Then I refer the court, and these are the most relevant authorities now, the ones that I am going to refer the court to. They apply directly to the matter, but it shows is not even relevant given what it is about. So Enfield v. ENFIELD v. Planning Commission. The citation is Corporation of the City of Enfield v. Development Assessment Commission. Citation is 2000 HCA 5. This was a per curiam decision of the High Court. And this is what the court said. The nature of the jurisdiction, this is the administrative law jurisdiction, was explained by Bray CJ in Attorney General v. Huber. In Batemans Bay Local Aboriginal Land Council v. Aboriginal Community Benefit Fund Pty Limited and a few other cases, and this is what was said in those cases. In this field, equity has proceeded on the footing of the inadequacy, in particular the technicalities hedging the prerogative remedies of the legal remedies otherwise available to vindicate the public interest in the maintenance of due administration. What was said in this authority and Tui v. SOAR v. Tui TOOHEY, ex parte Northern Land Council, another per curiam decision of the High Court. This is, the citation for this is 1981, 1981, 151 CLR 170. In this authority, Enfield and a number of other authorities of the High Court, which the court has only gone more liberal in the direction of declaratory relief, they have clarified, and again, one of the other really important authorities is Strickland v. DPP. This is the most recent one. So Strickland, STRICKLAND v. Commonwealth Director of Public Prosecutions 2018, 266 CLR 325. What was said in that authority is that if the court does not determine allegations against the executive, allegations that are of the nature of corruption or a perversion of the course of justice, then it necessarily brings the administration of justice into disrepute. And I refer the court to paragraph, so this is paragraph 249, abuse of process, may not be the best language to describe the category where the focus is upon the integrity of the court generally rather than its particular processes. The rationale for this category has been described in various ways. The rationale has been described as being a responsibility for the maintenance of the rule of law that embraces a willingness to oversee executive action and to refuse to countenance behavior that threatens either basic human rights or the rule of law. 237. It has been described as avoiding an erosion of public confidence. It has also been described as arising where a trial would bring the administration of justice into disrepute. Each of these verbal formulations attempts to capture a concern for the systemic protection of the integrity of the court within an integrated system of justice. The possibility of an unfair trial or a degree of unfairness in a trial may be a factor contributing to that concern. In none of those cases was it argued that self-represented litigants were practically bullying or being oppressive to the premier anti-corruption agency. I hope actual criminals are not hearing this, otherwise it would remove the fear of IBAC. To whatever extent it is a deterrent, I don't know. The point is, Your Honor, that the original decision that the court has to make in respect of the impropriety, allegedly, of the conduct, we have put the evidence we needed to. The additional evidence, if there is any, is only to the extent that it contributes to the, what is called, consciousness of guilt determination, which is a very relevant factor in these matters. Post-offense conduct or forced dishonesty conduct.
So are you suggesting that you wish to put on additional evidence about now?
Are you suggesting that we cannot?
Well, the time's passed for that. The orders have been made.
How has the time passed?
The orders have been made. Orders have been made. You haven't complied with them. Are you making an application to put on further evidence?
I have already put on an application. I have appealed the matter. And what Mr. Brereton was saying was highly inappropriate. If we have a right to file the evidence that the law entitles us to file.
No, you don't. You have to comply with the orders of the court. They're not just mere suggestions.
Your Honor, if the order was the order of the judicial registrar.
Yes.
If it's made without authority.
And today's the day of the trial. And time's passed and you did nothing about it.
That's not okay. Your Honor is saying that without giving us an opportunity to be heard.
You've had more than an adequate opportunity to explain.
No, okay.
So is there anything further you wish to say? Otherwise, I'm going to rule on the adjournment.
No, we obviously want to file additional evidence.
Yes.
That was the whole point of filing the appeal, that it was prejudiced. And everybody's on notice of that. The other matter that I wanted to raise was the matter of whether or not there should be a public hearing. It is an incontrovertible fact that.
It is a public hearing, isn't it?
No, Mr. Brereton wants things to be done on written submissions.
No, we haven't got to that yet, even if we get to it. So that's beside the point. It was something I floated before lunch for you to think about. It's not a matter in relation to, we haven't got to.
It's more desirable than lighting myself on fire.
Okay.
To be euphemistic about it. Your Honor, the fact is that I am not breaking any law. I am glad that Mr. Brereton can sense my dissatisfaction about the fact that during the mediation when.
Well, we're not going to you.
No.
We're not going to that.
No,
There's nothing more to be said, Mr. Kuksal.
There is something else that needs to be said.
Well, if it's relevant to the.
It is very relevant.
Well, so you say. But make it relevant, will you?
Well, you have to hear me first.
Well, so far we have now wasted half an hour, where there's virtually been very little in response, if anything, to what Mr. Brereton has put other than you say it's not an abusive process. That's.
Well, then, Your Honor, you've not been paying attention, respectfully.
That is absolutely scandalous thing to say to me, Mr. Kuksal.
That's not fair. That's not fair.
That is a scandalous thing to say to me.
May I identify what I've said that's relevant? You said I said very little.
No, I have made an assessment of the merits of what you've said. Now, the only point that I have given any weight to in what I'm thinking about is that you say there's no abusive process, and you've explained why. Excellent. Now, what are...
No, but it's also relevant to the fact that what Mr. Brereton is trying to characterize this proceeding as is, perhaps, a petty dispute over a monetary amount. Whereas what I'm trying to clarify or emphasize to the court is that if what we're alleging is actually happening, the court must check that because it will.
Mr. Kuksal, this application that you and Ms. Zhu have brought, offer certain orders.
It's a public interest litigation. You just sighed. I would like this on the record that you sighed and you made physical gestures which expressed frustration.
Absolute frustration because you are wasting so much time.
Because I said this is a public interest litigation.
And you are having difficulty in responding to my directions.
Your Honor, they have said that our complaint was a public interest complaint.
Yes, but there's a word, the use of public interest complaint in the context of the legislation that they have to make a decision about under their legislation.
In there, sure.
That's a particular caliber of public interest or however the proper terminology is.
Yeah.
That is not the same as categorizing certain litigation as public interest litigation.
So Your Honor has determined that this is not a public interest litigation.
I don't have to determine that.
Yes, you do. How do you exercise your discretion otherwise? When you're listening to me, when you're deciding how much time we should get or whether we should get another opportunity, it is the foremost consideration.
Mr. Kuksal, you're being your own worst enemy. If you can only stick to the points, to the matters that are relevant to the issues that we have to determine, we will proceed a lot easier. So I've asked you.
I am a very ideological person, Your Honor. I have asked you to respond.
And
I'm not, yes.
To the adjournment application. And now you're going into.
One other matter that is very relevant, Your Honor, is that there is a lot of material here and no human being can go through all of it and process it without some guidance from the parties that were there. There is a great density of material, and part of it comes from the fact that the IBAC has always tried to hide things as much as possible. And it's only because I pushed and I pushed and I pushed. And I'm supposed to help the court in understanding the matters that we've reached the place that we've reached. Now, I refer the courts to an authority. It is Mahin Thirarasa.
The relevance of this authority?
Is that the authority clarifies that the executive has a shared duty with the court to help achieve a transparency in government and a determination of the truth. And where the executive does not cooperate with the judge, it is, effectively, committing fiduciary fraud. It is the executive's duty to come to the court and even confess or admit when it has made false, Because there cannot be any justice if the fountain of justice, as it was called, the Attorney General was referred to, himself not a moral exemplar. Again, a term that was used in the authority. So there can be no argument that it is in the public interest that government officials act commensurate with fiduciary roles and are held to account in the strictest possible way when they make mistakes. So to argue that the getting into specific details may not be materially relevant to everything here misses the point that, in Lang v Australian Broadcasting Corporation, this is a High Court authority. The court had clarified that every citizen and resident of the country has an obligation to criticize the government and to signal to other citizens about the malfunction. Because they all rely on the benefit of the other person doing it. Every mistake, every improper conduct, when it is clarified, 1, it sets the record straight for the executive. Sometimes they make mistakes not knowing that they're making mistakes. The court then checks them. It solves a number of other problems. But, more importantly, if the executive can be convinced or can be assured that through technicalities or through whatever other means they can somehow evade accountability, then it incentivizes corruption. And it incentivizes a cover-up of the corruption. And it is not possible, at this stage, for the agencies that we say are corrupt to do anything about things because we have been in the process of publishing everything online, all the evidence.
Sorry, Mr. Cooksall, how is this relevant to the adjournment application?
It is relevant to the adjournment application because what I'm saying is that the manner in which the court places importance on the determination of truth, Your Honour, is coming from a civil procedure perspective. Expedition is not as an important criterion on the criminal side or administrative law side as it is in civil procedure when monetary disputes are in question, because what you're penalizing or keeping away from someone is a certain amount of financial benefit. And the rationale there is this: by not being very efficient they are leading to a financial burden on the rest of society, and that burden is not justified for the financial gain of the party that is making the application. We're not comparing like with like here. What we are pursuing here is justice of a type that is not monetizable. Our reputations have been harmed, we want vindication. And then, there's the public interest in holding corrupt officials to account. And none of that is to say that we can make those allegations without proper basis. If we are making those allegations improperly, I'm sure Mr. Brereton would bring defamation proceedings against me when I say the same things about him outside as I did here. So while pointing to the transcript of the umbrage that he had taken inside, so he should do outside as well. But the point is, Your Honour, that are ways of stopping us if we are abusing this proceeding in a manner other than something which is completely untenable. So if we are being vexatious, they can apply to the court for a vexatious proceedings order. If there's any other proper basis, they can come and use it on that basis. What they're trying to do is asking the court to exercise its discretion in a manner that is incompatible with the exercise of judicial discretion by invoking authorities which were never meant to be used in the context in which they are being used. I'm saying this, Your Honour, because Mr. Brereton has been making a number of submissions about how we've been tardy, irresponsible and so on and so forth. And, let's say this, in the worst case scenario, let's say I'm completely dishonest and I have been what is saying, or completely misguided and, in effect, I have been what is saying. Even then, it would be a travesty of the course of justice if corrupt police officers and corrupt IBAC officers could get away with committing serious indictable offences.
But, Mr. Cooksall, that's not what this case is about.
This is what, Your Honour.
This case is about a decision made to investigate. It's not what the outcome of it might be.
No. Respectfully, Your Honour, what these authorities that I've cited to you.
No, Mr. Cooksall.
Let me.
None of this is relevant to the adjournment application.
No, if you could just give me 1 minute too.
No, I have.
No, 1 minute. Your Honour, it will take longer argue whether or not I should get the time. I'm just asking for a couple of minutes. What I'm saying is that these authorities clarify that the maintenance of the rule of law.
I understand the maintenance of rule of law.
So this is how the rule of is maintained.
Okay, right. I get the rule of law. I get the arguments about the abusive process. These matters don't assist me in further exploration of this, in making a decision about whether or not an adjournment.
I'm saying if you're tardy, you penalize us for the cost order after deciding whether or not we should.
Okay, well let's just get on with it.
Yes, but what I'm saying is if there is a possibility that what we're alleging is true.
Yes, but that's not what this case is about. This case is about you seeking to review the decision of IBAC, and not to investigate a certain matter.
Your Honour, respectfully, this is a legal question, and the question is this: whether the right to have the government perform responsibly and in a manner that is commensurate with.
Mr. Cooksall, you are misguided.
I'm not, Your Honour.
So I think that it's not taking us any further.
What I'm saying is that, even if this is not a criminal proceeding or a disciplinary proceeding of the sort, that would.
It's not. Yes.
And I accept that, but it does not change the character of the proceeding in the sense that this is an accountability measure, necessarily. And if the court does not look at it that way,
Your claim is that IBAC committed a jurisdictional error or error of law in dismissing the plaintiff's complaint.
yes,
That is your claim.
but that's the determination we're seeking.
Yes.
To make that determination, the court has to determine matters of fact.
But then your grounds relied upon or rely on
Human rights.
aspects of the legislation.
Human rights is the declaration. We're seeking declaration. We're not seeking any relief.
Yes, that is relief.
What I'm saying is material relief. We're not seeking material relief.
Well, I understand that. I can read your pleadings.
But, Your Honor, if they have broken the law, we have a right to seek that in relation that they.
But that's not what.
That's what we're seeking exactly.
All right, well, this is a waste of time, because
But, Your Honor, this is helpful in this aspect.
I am going to rule on the adjournment application because it is now 3:15. It's almost 3 o'clock.
Okay, just one thing, Your Honor, because I think it will help the court.
And we need to know, it will not help me in any.
Very little time.
No, that is it.
A couple of minutes, promise you.
No, you have had more than adequate time.
But, Your Honor, you raised something which I think I should advise you about or clarify, rather.
No, please, you have had more than adequate opportunity to respond to the adjournment application.
But this is a new matter that you've raised and I just want to address that quickly.
No,
At least hear me about what the matter is.
no, enough.
Your Honor, respectfully, you don't know what I'm going to address you about.
I am, unless it is to do with the adjournment application.
It is.
All right. Well, tell me what it is, and if it isn't, I am not going to be happy with you, at all.
But that requires me to know as much as you do. For me to know exactly whether or not you will accept what I'm saying is.
But if it's not relevant to the adjournment application, it is irrelevant to something I have to decide right now.
Okay, what I'm saying is that it was also said that the evidence, this is directly relevant to the adjournment application, that the evidence is all documentary evidence. Now, this is for IBAC's benefit as well. The evidence has been filed in this proceeding for over a year, the substantive evidence. It was referred to before Justice Ginane. None of the evidence has been challenged by any of parties, say parties. The first day this and the related proceeding was on, about the same matter, Justice Osborne, who had heard the matter in the practice court as an urgent thing, His Honor had commented that the allegations that we're making are extremely serious. They show very serious misconduct by the state, police officers and so on, and he would be shocked if the state had nothing to say in response. They've said nothing in response for, this was 2023, the 4th of January. They've said nothing to contest the authenticity of the recording. In fact, in the magistrates.
Mr. Kuksal, this is not.
No, this is adjournment, let me just.
This is not relevant to the adjournment?
Let me clarify what I'm saying.
No, this is not relevant. It is not relevant to the case.
No, Your Honor, I haven't finished, Your Honor. What I'm saying is.
Mr. Kuksal, you have finished.
No.
You have finished. There is nothing further that, in this direction, is going to be of any assistance.
I have not finished. What I'm saying is that.
What someone might have said in another time, in another place.
No, that I was saying for emphasis. What the main point is this, if they do not present witnesses to, basically, contradict our evidence.
Mr. Kuksal, the court book does not contain any evidence you haven't participated in that. As far as I can see, it's a pretty straightforward.
They've created the court book. They've not included the.
Because you chose not to participate in the preparation.
That is absurd, Your Honor. That is absolutely absurd. What you're saying is, even though you can see, in Redcrest, all the documents that have been filed in this matter and have been referred to in previous judgments in this matter, you're going to argue that because, and you don't even know whether we actually responded to them or not, which we say we did. But it doesn't matter because he's a lawyer and doesn't matter why we wouldn't have responded. But because it wasn't identified in the court book that we would rely on the evidence that we have filed, I mean, why would we have filed the evidence if we didn't want to use it in the trial?
Why do you leave it until today to raise these matters?
See, that's the question. That presumes that we have left it today.
Well, you have, haven't you? Because nothing has happened.
No, Your Honor, again, I think Your Honor's not listening to me. I've been saying that he's lying and that we've been responding to him.
No, you do not accuse a member of council in that way.
I absolutely do. There's authority, I can.
Okay, Mr. Kuksal.
If I'm wrong, then I'm doing something wrong.
I am not going to hear any further. I'm going to rule on the adjournment.
But Your Honor, it is improper to say that. He will say what he will say, and then I cannot.
Okay, sit down, Mr. Kuksal. I am going to rule on the adjournment. I have heard extensive submissions from Mr. Kuxel and submissions from Ms. Xu and Mr. Brereton in relation to the adjournment. I can see no valid basis on which the matter should be adjourned. It is important that we proceed to keep this matter going forward. I am going to refuse the adjournment application and provide reasons in due course. I have directed that any recusal application by 4 p.m. tomorrow. Mr. Kuxel, I now proceed to deal with the summons.
But sorry, Your Honor. The recusal application is still pending. But you cannot make interim. No, Your Honor, you cannot make a substantive decision of that sort.
I've made it. Please sit down.
Well, we seek.
Mr. Kuxel, please sit down.
I have a right to make this.
Mr. Kuxel, for the third time, please sit down.
We seek an adjournment so we can raise this matter with the Court of Appeal.
Please sit down. Mrs. Zhu can go and do that for you if she likes.
Sorry.
Mr. Kuxel, please sit down.
Your Honor, we seek.
And I want to proceed with the...
We want to be heard. We want to be heard.
No, I am not hearing any further. If you don't sit down, I will ask you to leave the courtroom.
You can kick me out, that's fine. You can kick me out, that's fine.
All right, well, take your computer and sit outside and join the...
No, I will not sit outside. I will not sit outside.
Well, sit down.
No, what I?
Sit down, Mr. Kuxel. I have already directed you to sit down.
I wish to be.
If you don't, mister, I will ask you to be escorted from the courtroom.
So you have, Your Honor.
If you ask me to leave, I will leave.
Okay, please leave.
Thank you.
I understand that you have access to the live stream.
No, I don't have. No.
It was sent to you yesterday.
No, I don't. May I get a couple of minutes with Ms. Zhu?
I will stand the matter down for 5 minutes, until 3:10, and then, on resumption, I will hear the application in respect of the summons. Mr. Brereton, I have read the submissions, I've read the application, so if you can take me briefly to the appropriate...
Yes.
Can I reply to the court that I have not read the summons or that there was no order for the matter to be tried today?
Mr. Kuxel, if you choose not to participate, then that's a matter for you.
No, you're kicking me out. But I...
No. In terms of the summons, if you haven't read it, it's been served on you a couple of weeks ago.
Yes, but there was no decision that it would be heard and tried today.
If you get a summons, it's at your own peril if you don't look at it.
That's absurd, Your Honor. There was no order by the court that the matter will be substantively determined today.
Mr. Kuxel, I've asked you to. I'm going to stand the matter down until 3:10.
So, Your Honor, I note for the transcript that I've just come back in after the recess. I wasn't watching the feed as your associate would know because you do not permit me in. I haven't read the summons. I do wish to note though that we had raised a complaint against Justice Gorton permitting criminal perversion of the course of justice to the IBAC, who has then used that information to prejudice us in a proceeding that we have brought against it. Mr. Brereton used orders or reasons from Justice Gorton earlier, and then Your Honor noted that you were aware of it because you made inquiries. But in any event, you referred to Justice Gorton.
Yes. I want to hear your response to the summons.
I haven't read the summons.
Okay, well, if you haven't read the summons, you've got no submissions to make on it.
No, I want to make submissions. I'm seeking an adjournment.
No, I am refusing that adjournment.
On what basis?
You have had sufficient time. It's been served on you.
It hasn't been served on me. There's no affidavit of service. I don't even know whether it's been served on me, to be honest. I have not acknowledged its service.
Just because you haven't acknowledged it doesn't mean you haven't got it.
No, but I don't know whether it's been served on me. I haven't seen it.
You haven't seen it or you haven't looked at it?
Sorry, I'm saying.
No, answer my question.
I am answering your.
Have you seen it, or you just haven't looked at it?
I haven't seen it.
Okay, so you say you haven't received it?
I haven't received it, yes. There's no affidavit of service before the court. How will you now, Your Honor, in my view, push your agenda? There is no proper basis for it.
All right, I want to hear from Ms. Zhu in relation to the summons.
But there's no affidavit of service.
Sit down, Mr. Kuxel.
I'm asking the court.
And I'm refusing your application.
No, I'm asking the court to produce an affidavit of service. It's my entitlement to contest the service of a document that I haven't received and that they haven't proved has been served.
Sit down, Mr. Kuxel. I'll hear from Ms. Zhu.
Your Honor, can I just first raise one inquiry?
Sorry, Your Honor, may I be advised about what happened in my absence so I have some context?
Mr. Brereton took me to his submissions, which have also been sent to you.
To who?
To you on the email that is your communication email according to the court record.
Well, did he give evidence about that?
We can tell from our own records.
So Your Honor has, herself, seen and verified that?
I've seen the submissions and I've seen the date on which they were filed. Now if you are
You've seen an email go out to me.
Mr. Kuksal,
I'm clarifying, Your Honor, what you were saying so I know exactly what you had said. Are you saying that you have?
you have said to me that you have not seen, nor looked at the summons or the submissions, so I take you at face value, and I want to hear from Mensa Zhu before we go any further.
But are you, both of you?
Sit down.
May I just clarify what you understand?
No, sit down.
I don't know whether you are of the view that they had served it and I didn't look at, or whether.
I have not formed a view about that. I have heard what you had to say.
But you just said that you had seen an email and it's been served on my email address.
No, I did not say that.
Your Honor, the transcript will say you said that it has been served on my email address, the email address that I've provided to the court.
That is the email address we've been communicating with you.
So you've seen the email go out to that.
The email that we communicate with you.
But they sent the submissions, though. So you haven't sent, or your associate hasn't sent the submissions to me.
Sit down. I'm hearing from Ms. Xu.
Your Honor, this is troubling. I am very troubled by what has transpired today.
Ms. Zhu,
Yes. So first, can I inquire that I appreciate it if the court can give me some clarification as that, when they say they seek redactions about just in terms of our ability to talk about it publicly, would it affect any?
Sorry, Your Honor. Sorry. I'd rather be kicked out because this is perverse.
okay, well, more than happy.
This is perverse.
More than happy for that to happen. You can leave. Again, Mr. Kuksal,
I'm not leaving again, I'm being kicked out.
Mr. Brereton, perhaps before we, Mr. Brereton, are your instructors able to provide information about the...
We're just hunting it down now, Your Honor.
Thank you. All right.
So they haven't provided any information to the court as of now, and you have already made an order.
No,
Yes, you have. Your Honor, you have made orders. You said that you had made an order. You are not listening to me, again. I raised the point, then, that there was no affidavit of service and that you shouldn't have made the order.
I haven't made an order.
You made an order that it will be heard today without knowing that it's been served.
I want to hear from Ms. Zhu.
Your Honor, this is dishonest. This is plainly dishonest because it could not be innocently misrepresented to the extent to which,
Well, I have asked Mr. Brereton to...
after making a decision that it'll be heard today.
No, I want to hear. I'm sorry, Mr. Brereton.
So,
It doesn't matter now, anyway.
my learned instructor, Ms. Champoli, has previously provided unsealed versions of various documents including the summons. But I'm currently looking at an email, Friday the 1st of November at 6:54 p.m., sent to Mr. Cooksal's email address, which is the one that's been listed as the one he seems to be contacted on shivish@rightofreply.com.au and to Ms. Zhu at lulu@rightofreply.com.au, also.
Do I cross-examine him here about this or?
Also.
Mr. Kuksal, do not...
Is he giving evidence from the bar table, Your Honor?
Do not interrupt.
I'm objecting
Sit down, please.
to the evidence being given from the bar table.
Sit down, please.
And just to clarify or fortify Your Honour's point, the Supreme Court's email address judicial review of the supremecourt.vic.gov.au was also an email address that same email was sent to, consistent with what Your Honour just said a minute ago about.
No, that's not what Your Honor said, and Her Honor actually contradicted herself a number of times.
Is that the copied into a subsequent... Is there subsequent email or the same email?
The same email.
Same email.
Sorry, Your Honor.
Mr. Brereton, would it be possible for your instructor to swear a short affidavit?
Certainly. I was about to say, well, I can arrange for an affidavit to be.
Thank you. I want to hear from Ms. Xu.
No, I want to just raise the point that it was said in Strickland v. Commonwealth Director of Public Prosecutions that ours is not a system of governance where the executive and the judiciary exist in a continuum. Today, what has happened with Your Honor being dishonest to cover loopholes in their ability to persecute us, it brings the administration of justice into grave disrepute.
Mr. Kuksal, I have seen the...
Your Honor first said that you had seen the email that, to which,
My recollection was, I saw the email that was copied to us, that is to the court and to the affidavit.
but then you said you hadn't seen the email. You had only seen the submissions. You have said this. You have contradicted yourself, and it has only been discovered because I pressed you.
Mr. Kuksal, you are being offensive. Please sit down.
I'm not being offensive, Your Honor. You're being offensive.
Please, sit down and or leave. Whichever you wish to do, but I don't want to hear any further from you, at the moment. I want to hear from Mrs. Xu.
Thank you. This is scandalous. This is absolutely scandalous.
Leave the room.
Thank you.
Ms. Xu, do you have a copy of the summons and the submissions in front of you, do you?
Yes, I can access it.
Now, I'm not sure whether the question I asked Mr. Bresson at the end about the implications of the orders being, it's not that the parties, as in you, Mr. Kuxel, counsel and myself, are prevented from access to that information, it's just outside of those limited parties that the information is identified would not be available. They'd be confidential. So it is just a matter of managing the information which, on its face, is subject to a restriction as a consequence of the operation of the legislation. So in those circumstances, do you have any objection to the orders that they are seeking to make for us to manage that information?
Yes, first of all, just based on my understanding, because counsel said that those information were already available to us. So if we are otherwise, prevented from disclosing it or talking about it publicly, then we can already or could have already done that. And in terms of, I think, the specific piece of information that I think can be of some issue is the new outcome or the new outcome that was given by the advice, but it's been discussed multiple times. So I don't think there is any need for it to remain secret because there's no longer a secret from long time ago. I think we have been discussing about it also. I think Public Interest Disclosure Act talks about IBAC, and they cannot disclose certain documents. That may cause some harm to me or to other complainants. It's an obligation that they have. It should not be imposed to us. This case is a bit special. That's because in the ordinary sense, IBAC, when we make a complaint to IBAC, and then they've decided this outcome, and that outcome is subject to some restrictions for confidentiality, then I think it's more appropriate for that assessment now going to be kept confidential if necessary. But in this case, we have reviewed their decision and say that your decision is wrong. And then after we come to the court where Ria Salaris, a place, is supposed to be an open place, where everybody have been talking what's been going on. So I don't think because information had been already being discussed in open court and it's being live streamed, it's been published in judgments, I don't think it is not necessary anymore to keep a secret, and I wouldn't say that IBAC is necessarily going to contravene the Public Interest Disclosure Act by doing that. Because they've given it to us, and if they are using them in this court proceeding where we are reviewing that decision for whether or not to investigate the police misconduct, it's being used so those information are being used in the course of the proceeding, and normally I understand that if, an investigation or something, maybe a criminal or murder investigation should be otherwise kept secret, the investigation should not be disclosed to the public. But when it goes to court then it becomes public, and I think that's perhaps why there hasn't been any authorities there yet. But I think the court should bear in mind is that this proceeding is a little bit different than the normal course how the indistinct would operate. That's because I'm repeating it, but that is because we have first reviewed their decision, and then they have made a different decision or a new decision that they say they want to keep secret. But my argument is that because that new decision will show that they have made the wrong decision in the first place, that's why they don't want to be disclosed or they don't want us to talk about it, but it's already in the public.
Except that it's not the decision is seeking to be, or the process or the proceedings that are being some confidentiality arrangements are being put in place. It's some of them, the material which is the subject of the complaint, which under the legislation is required to be kept confidential in certain circumstances. But that's no disadvantage to you or Mr. Kuxel, because you have access to that information, and you can refer to it and you can make submissions about it. It's just that in the context of this hearing at least, it's protected from further exposure by the confidentiality arrangements. So the fact of the proceeding is not confidential. The fact of, you're making this application is not confidential. It's just those particular items, item 11, 13, 14 and 4b, of their submissions that they wish to restrict access to.
Okay, but that wouldn't affect our ability to publish it unless there are otherwise prevented by other ACTS
reasons. It would if it's confidential. It remains within this court process unless a different court order is made or some other provision applies.
But that's a suppression order.
No, it's not a suppression order. It's an order made under the Enforcing the Public Interest Disclosure Act.
And also there is one part about the transcript of the last November hearing. I'm not sure why that need to be
before Justice Janine.
Yeah, it's already in the public.
Transcript generally isn't on the public record as I understand it, it's for the parties.
I read about that somewhere, I'm not sure.
Court documents and affidavits and the like, if they're admitted into evidence then they can be accessed by the public. But there's not normally a situation where the transcript's on the court file as such. It's not a court document as such, it's a recording that the parties have access to. It's not a court document, it's a record of what happened in the court.
Yes, but if it's already in the public, why now making an application to suppress it?
Well, I'm not too sure where in the public it is.
Well, we have sent it probably to other parties, the court transcripts. They're very public and open documents.
Okay.
And also they have been in the public perhaps already, unless it's prevented. So I do not see why, and I do not see any harm in having it known to the public. So I will say that I have not identified the exact public interest that it will cost or it will harm by having it kept confidential. Everything had been very promptly discussed in open court, so there is no reason why they want to impose further burden on us, so we are not allowed to raise this or talk about it in public if we want to. If it is an offense to talk about it, we will be aware of that, but this proceeding is after we have started this proceeding and then those documents had been discovered or a new decision has been made. They are the results of us making the efforts to the court to have them produced, so I don't think there is any reason why. I don't know if I'm a proposed protected person. I am so fine with having it disclosed, and I don't think they are worrying about mine and, indistinct. The other thing is very ironic is that when we first made the complaint to the IBAC, we told IBAC officer that because Channel 9 had been publishing the video taken by the police, so the videos of our house had been public and I have someone come to my house and they cut off the electricity, so for a week there's no electricity. Sorry. I don't think IBAC had really considered the welfare of the complainants so much when they were dealing with the first complaint. And now it is my submission that they do not want to be made accountable for the first decisions they made, which we say were wrong. And that's why they want to consider those informations, and I do not see any issue with them being a public knowledge. Things have been said. There is nothing that it is effectively a suppression order, because then the court will expect us not to talk about it. And I think it is our intention to have those information being published, and we can openly either criticize IBAC or make complaints, talk about it somewhere else. They are in the open court, and I do not see why an order that amounts to a suppression order, or have the such facts, should be imposed to us. But otherwise, if the court only asks the other party that is completely irrelevant to us not to search it, that I'm happy about. But if we wish to use it outside court, then unless there is any other restrictions, I don't think there is any reason why we shouldn't be able to do that.
Okay.
Yeah.
Thanks, Ms. Zhu. Just to deal with that point, Mr. Brereton, of the information being available earlier.
Yes.
And then because of the impact of the legislation, a different regime effectively is in place. Have you turned your mind to how we deal with that?
Well, Ms. Zhu is quite right, to the extent that before it was assessed as a public interest complaint there was a lot of information that was published.
In the public domain, yes.
And that is the explanation for why the proposed redactions in their current form are much more
restricted
than they would have been. So the primary task we have undertaken is to propose redactions of information about the content of the complaint that has not otherwise been disclosed. So it is very confined. That is the first thing. So we haven't sought to have the protocol or the orders that we seek applied to the information that Ms. Zhu has identified as already having been in the public domain because of whatever steps they've taken. And we have limited it just to those aspects that we have, after a thorough search of transcripts and judgments and things of that nature. I should withdraw transcripts. Published judgments primarily and then other sources, because we have taken a very cautious approach to the transcript, where we have taken the view that things that are on transcript aren't necessarily disclosure for the purposes, aren't disclosure for the purposes of the regime, but something that is written in a published judgment plainly is, because it is available to the world at large. As distinct from transcript, which, as Your Honor pointed out to Ms. Zhu, I think, is dealt with slightly differently and requires various steps to be taken to be able to have access that material. So that is the first thing. The second thing I would say in relation to the submissions that Ms. Zhu has made is that this isn't a suppression order, this is preemptively dealing with an obligation IBAC has. The plaintiffs don't have that obligation, it is an obligation IBAC has as an entity under the legislation to whom accessible disclosures may be made, and who is an entity that must assess that accessible disclosure and determine whether or not it is a public interest complaint. So if, for example, Ms. Zhu was to take the view that the particular document that most relevantly concerns her, or most squarely concerns her, which is the most heavily redacted of the documents in the court book, P36 of the court book, that is effectively her document. And because this isn't a suppression order, she could do with that document what she wishes. But that's not to say that, in circumstances where, as things presently stand, that is a document that, as far as we understand it, is confidential as between ourselves and Ms. Zhu, albeit it is relevant for the purposes of this proceeding and by reference to the, or by application of the court rules and the usual procedures we seek to rely upon it for the purposes of this case. And we have the obligations arising under the PID Act in those circumstances. That is not to say that it is suppressed for Ms. Zhu's purposes, whatever those purposes might be, publication or whatever else it was that she was referring to. So that was the second point I wanted to make. Unless there was anything else, Your Honor, I don't think there was anything by way of reply that I necessarily wanted to say.
Yes. I understand how you put it, thank you. I am satisfied that it is appropriate to make the orders sought in the summons, and I will make those orders. Mr. Brereton, can you provide a draft form of the order?
I can, yes, Your Honor.
Thank you.
And Your Honor's preferred timing in relation to that is today or tomorrow?
Well, I suppose the next question really is what we do with the trial, the balance of the matters that we were to deal with today. Obviously, the order needs to be made prior to the commencement of the trial.
Yes.
So if that can be done overnight,
Yes.
the question is, can we resume tomorrow? And I am unsure whether or not that it is a possibility, both from our point of view or anybody else's. The matter is listed for 1 day. It is unfortunate that we are in this position. But I might just make some inquiries. If the associates could make some inquiries.
Sorry, can I make a? I don't think it's going to be 1 day because we do intend to, if go into the substance of the case, then we will go through the audio recording. And, the main complaint that was made to IBAC, that was actually very extensive, and a lot of the things that happen I will need to take the court to, and we will have to hear quite a lot of recordings. I am not being difficult about it, but obviously we are here to argue that, the human rights perspective, and wish to present to the court that's why they are so adversely affected by IBAC dismissing that complaint in the first place. I think it will take some time.
Unfortunately, the orders that have been made as to the conduct of this trial had indicated that the trial would be 1 day, so I am not sure how that estimate came about. I am just wondering, though, before we continue on this conversation, whether Mr. Kuksal should be asked to return. Thanks, Mr. Helmkin. Given that we need to discuss, really, how we proceed from here. So we might just wait a moment.
Now that Mr. Kuksal is here, can I just raise one issue?
Sorry, no. 1 second. I want to clarify that I was told that I was now allowed into the courtroom. I have no idea what the context of the matter is and how far we've gone in pursuing IBAC and Your Honor's corrupt agenda in my absence. But,
Mr. Kuksal,
let me be clear,
allegations are not appropriate.
You lied, you got caught,
Mr. Kuksal,
Your Honor, I'm not hesitating from that. You can hang me if I'm wrong. I saw you lie, I saw you nervous, I saw you try to evade things and then change your story. I saw him try and cover.
Mr. Kuksal, I gave my answer as to my recollection as it was.
The judicial review email addresses the registry email address. Why would you have access to that? And BPAC to cover for you?
Why? Because I have access to all of the court documents.
No, that's not what was being discussed. You discussed the email address. He tried to explain how you would have had knowledge of the service.
No, I said it was my understanding.
No, I'm talking about what he said.
Well, I don't, whatever he's...
No, but this looks horrible, Your Honor. The Anti-Corruption Agency.
Mr. Kuksal, I am about to explain to you what has gone on in the last few moments, when I said...
Well, I don't trust what you say now, by the way. I don't think any reasonable person would.
Well, Mr. Kuksal...
Your Honor, just an artificial intelligence program would definitely be confirmed that what has happened gives more than assumption basis for Your Honor to lose jurisdiction. I do not consider this matter to be open to any extent to reasonable debate about whether or not the appearance of impropriety or bias arises, at least.
Mr. Kuksal, I am going to explain to you...
It doesn't matter what the truth was actually, by the way.
I explained to you what has gone on.
You lied. You changed your story a number of times.
Mr. Kuksal...
Your Honor, I am firmly of the view that you lied. Now, if you tell me that you didn't lie, it's sort of a self-defeating proposition.
Mr. Kuksal, sit down. Sit down, or I will ask you...
No, unless you think that I'm...
Sit down.
That I have no basis whatsoever, in which case you should charge me with contempt. But if you do...
You've tried that.
Then you're conceding that there's a proper basis for it to be.
I know you've tried that on a number of other occasions, Mr. Kuksal, but you're not gonna...
Yeah, I'm sure Justice Gorton and you have discussed that when you discussed how to neutralize my legal submissions.
Mr. Kuksal.
This is scandalous, Your Honor. You just accused me.
Mr. Kuksal.
Sorry, you just accused me.
Mr. Kuksal, sit down.
No.
Mr. Kuksal, sit down.
You just accused me.
Would you ask Mr. Kuksal please leave the room?
Thank you. It is offensive to be here.
Now I am told that IBAC, there is a court available to us tomorrow so we can proceed tomorrow. So I just want to see what arrangements can be made. It may well be that that's not the appropriate course, but at least with the opportunity to continue to hear the matter.